to today's program, Parenting Under Siege, Reckoning with Coercive Control, which will feature Professors Courtney Cross and Jillian Chadwick. I'm Jane Stover, and on behalf of the UCI Initiative to End Family Violence, I want to welcome and thank everyone for joining us today. The UCI Initiative to End Family Violence unites faculty from 21 different departments and 11 schools across UCI with community partners in interdisciplinary research, education, and clinical interventions in family violence and gender-based violence across the lifespan. In addition to directing the initiative, I'm a professor here at UCI Law School, where I direct our domestic violence clinic. Within the clinic, we represent abuse survivors and their children in a range of civil, criminal, and immigration and policy interventions in abuse. And our clinic has been especially active in working on some legislative reforms to improve protections for domestic abuse survivors and children, with one being to expand our state's civil definition of domestic abuse and coercive control to include reproductive coercion. And this topic of coercive control is one that has received a lot of attention in the last decade plus since Evan Stark first published his book, Coercive Control, back in 2007. And now that some states are including coercive control in their civil definitions of domestic abuse and restraining orders. And of course, in representing abuse survivors, we see many cases, I would say, of post-separation coercive control through custody and litigation, as Dr. Emma Katz has really explored. And today, we are fortunate with the initiative to be able to bring you two incredible people who are great scholars who've published recent impactful articles on coercive control that they'll be speaking from and identifying for you. They are really talented, courageous clinicians, educators, and dear friends. I admire them so much and how they are thinking really critically about the complexities of litigating and legislating coercive control, and thinking about cautions for various contexts so that seeming advancements aren't utilized against abuse survivors. So our featured speakers today, I'll start by introducing Professor Courtney Cross, who is a professor of law and the director of the Survivor Representation and Advocacy Clinic at UNLV's William S. School of Law. Her research focuses on the intersectionality of domestic violence, criminal law, poverty, and public health. Courtney, Gilly, and I share a lot in common, and one is that we all started as teaching fellows, clinical teaching fellows. We started our work in terms of being professors as clinical teaching fellows at Georgetown University Law Center's Domestic Violence Clinic, although I was some years earlier. But it's been wonderful to find all these connections over time and to be able to build thought together. Before becoming a professor and before her fellowship at Georgetown, Courtney served as an Equal Justice Works and AmeriCorps Fellow and staff attorney at a women's reentry nonprofit in Washington, D.C., where she represented formerly incarcerated women in domestic violence and family court proceedings. And she's also represented incarcerated women in parole revocation hearings. Also, so happy to introduce to you Jillian Chadwick, who's a professor of law and director of the Children and Family Law Center at Washburn University School of Law. Prior to her fellowship in Georgetown University Law Center's Domestic Violence Clinic, she was the director of survivor services at IUDA in Washington, D.C. in the Domestic Violence and Sexual Assault program. She also worked as an Arnold and Porter Equal Justice Works Fellow at WEAVE, which stands for Women Empowered Against Violence, where she focused on economic and employment issues facing abuse survivors and survivors of sexual assault. I'm so happy to welcome you both today and to thank you for sharing all of your work with our audience. Thanks.
Thank you so much. We're really excited to be here. And I can say, I have looked up to Professor Stover for a long time, including I went to law school at American when she was there, and I just hoped to one day be as smart and accomplished as she is. So I'm really excited to be here and share in this topic and continue the journey. So I guess I'll just add to the introduction kind of a little bit about what I do now, which is I practice in Topeka, Kansas. And the reason why I want to kind of emphasize this is because A lot of our talk today is going to focus on the importance of context and, the fact that what might work in one context might be a challenge in another context. So I'll say Topeka has 125,000 people. It is the capital of Kansas. People think of Kansas as a rural state, and it certainly is. We have 105 counties and 31 judicial districts, which means we have a lot of counties that do not have a courthouse in them. So there are certainly a lot of survivors in very rural areas in Kansas. And so I get kind of a view of being in Topeka, working on a legislative committee that has members from all over the state. So we're working on rural issues as well. And I also began my practice in DC, which obviously is a very different context. And so, that has been such a lesson for me in the progression of my career. And I know Courtney, coming from Alabama and now being in Las Vegas, has her own perspective. So I will pass it to Courtney to finish her introduction, and then we will get to it. Thanks.
Awesome. Thank you so much. It's great to be here. I, like Jillian, have long looked up to Jane's writing, and am so happy to be in circles with these folks. Jillian and I, as folks with overlapping Equal Justice Works fellowships, have actually known each other since 2010 and have been talking about, debating, discussing these issues basically ad nauseum since then. So it's really fun to be able to be here with her doing this. Because even if we weren't here with all of you, we would likely be having the same discussion amongst ourselves. So it is nice to be able to share some of these ideas. And we're really hoping to hear from other folks and learn. What we're talking about today is something that we grapple with so much. And like Jillian, I spent the last 6 years in Tuscaloosa, Alabama, Roll Tide, which was a college town that very quickly turned into a sprawling rural county, where I think I could say now that I have left, there was a bit of an anti-survivor milieu in the family court system, in the criminal court system, that has very much informed some of my own skepticism about how legislative fixes, how effectively they would serve survivors, and also sort of the ways in which they could be used against them. I'm now in Las Vegas, perhaps a bit of an overcorrection from Tuscaloosa, which is sort of a huge city in a state that is mostly rural itself, and so still sort of operating in those contrasts. So that is what is sort of forming the backbone of our practical experience. We think about coercive control both in the courtroom context and in the scholarship context. We're happy to be talking with you about sort of the dynamic and possible solutions, and sort of underscoring how harmful coercive control is for survivors and for children. And given what a pernicious and devastating dynamic coercive control is in families, it's really heartening to see so many advocates and community members and politicians looking for solutions, looking for ways to help survivors. And so we're approaching these legislative discussions from sort of a cautious and critical approach, because coercive control is such sort of an amorphous and multifaceted dynamic. We're urging the utmost sort of thoughtfulness and meticulous discipline when considering drafting this kind of legislation. And we will sort of get into the why as we move forward. But Jillian's going to start us off with a bit of a roadmap for the rest of the day.
Great. Yes. So we're going to talk first for a few minutes about what is coercive control and how our understanding of intimate partner violence has evolved to sort of include nuanced, multifaceted typologies of abuse. Then we'll turn to what coercive control looks like in the co-parenting relationship specifically, exploring that particular dynamic and touching on coercive control's damaging impact on children who are exposed to this abuse between their parents, either directly or indirectly. Next, we'll talk about the movement to criminalize coercive control and argue, maybe counterintuitively, that the anti-DV movement should be very skeptical of these efforts. And finally, we'll explore the potential for family law, legislative or other solutions, and flag some significant concerns with overly broad approaches and discuss how some of these challenges might be mitigated.
Awesome. So I get to start with sort of one of the fun historical overviews, looking at sort of how the DV movement in the last 50 years has moved from sort of a narrow focus on wife beating, which requires both a wife and an assault, into a really far more nuanced landscape in which there are multiple recognized types and typologies of domestic violence and intimate partner violence, and where things like intent and motive and pattern really matter. And I think that this conversation is important, one, to show you how far we've come and how effective the advocacy work has been. Two, to make sure we all have a shared lexicon of these different tactics and typologies of domestic violence. And three, to sort of underscore the fact that we are in the midst of an evolution and a revolution that is by no means over. And so as we're talking about sort of legislating coercive control, I also want us to remember that I don't think we've reached the zenith of our understanding of intimate partner violence. And I think that that is kind of a helpful backdrop as we continually try to sort of catch up to the social science with legislation. So as we're thinking about this evolution of understandings of domestic violence, it's helpful to think about starting in the mid to late 1970s, the first really unified theory about intimate partner violence to become popularized was Lenore Walker's cycle of violence. And this kind of tripartite cycle consists of a tension building phase, an explosive phase that includes acute acts of battering, a honeymoon phase where, you know, an abusive partner may show contrition and may sort of make claims or steps at getting better. But the crux of the cycle is that it continues and sort of moves faster and faster. And pretty quickly, the cycle became sort of a basic training tool for advocates, for judges, but at the same time was criticized for being vastly underrepresentative of what abusive relationships look like and overly prescriptive in this requirement of these phases and sort of the repetition of the phases. So when folks are looking at relationships that don't seem to have a honeymoon period, that don't seem to have a tension building period, or critically, that don't have that acute battering period, it's really easy for folks to then sort of cast those aside as non-abusive relationships. And so not long after, in the mid-1980s, the power and control wheel came out of Duluth, Minnesota, and it's a much more nuanced training and counseling tool. And what the wheel does that the cycle doesn't is, instead of sort of giving this prescriptive lifespan of abusive relationships, it provides a lot of different types of tactics of abuse that didn't exist in sort of the cycle's description. And so what we see here is isolation being used as a tactic of abuse, intimidation, emotional and economic abuse, blaming and shaming, using coercion, using male privilege and gender norms, and even using children against the survivor. And so even, you know, in 1984, we're starting to get these mainstream discussions of non-physical tactics of abuse, of sort of traumatic emotional violence. But what the wheel sort of assumes is that all of these tactics may be used in a relationship that also includes physical and sexual violence. And so the wheel is a real leap forward because it opened a lot of people's eyes and a lot of survivors' eyes to these nefarious tactics of abuse that don't involve assault or threats of physical violence, but they still assume that those things are happening alongside these other tactics. And yet the wheel is a really useful and prevalent teaching tool. Many of you, if you have done any domestic violence advocacy trainings, will have been introduced to it. It's a valuable tool, but it still presumes that sort of outer wheel of physical and sexual violence, which we will start to discuss, may or may not be present in a lot of relationships that are employing that three-dimensional tactic and tools of nonviolent abuse. And so then in the mid-2000s, we see a lot of social scientists, including Marianne Dutton, Evan Stark, Michael Johnson, Ellen Pence, and Shamita Dasgupta, suggesting, well, actually, relationships have all kinds of violence, and they're not all the same. Not all violence and abuse that occurs within relationships are equal. And so what we start to see is looking at sort of a separation of what Michael Johnson would call situational couple violence, in which members of the couple may be using maladaptive coping mechanisms to resolve conflicts, where violence is sort of a poor form of conflict resolution, often sort of arguments brought on by external stimuli or sort of stress outside of the relationship may result in violence being deployed to solve the problem or to cope with the issue, and contrasting that with violence that is intent on establishing power and control. And so we start developing these different typologies. We've got the situational couple violence. There's this idea of violent resistance, in which survivors who are being abused may fight back in order to, defend themselves, delay an attack, protect the kids, reallocate power dynamics in the relationship. And this violence is maybe outside of the traditional theories of self-defense, but is not being used to dominate or to assert power and control. It's being used by the survivor against the primary aggressor to try to reassert the survivor's agency in the relationship, to try to protect and defend. And then against that, there is this idea of intimate terrorism, which includes not just violence, but also tactics like threats, intimidation, monitoring. And the goal here is to undermine the survivor's will and their ability to resist. What the data has found over the last 25 years is that situational couple violence happens in somewhat equal rates across genders, but that this idea of intimate terrorism is most frequently seen as used by men in heterosexual relationships. And then the last typology that Johnson and similar to Pence and Dasgupta talk about is a really rare subset called mutual couple violence. It's when both partners may be engaging in intimate terrorism at the same time. This is a hotly contested typology. A lot of folks are sort of debunking it as sort of a misunderstanding of intimate terrorism coupled with acts of resistive violence. But these are some of sort of the main ways that you may see social scientists looking at, evaluating, and assessing intimate partner violence. And at the same time, we see this idea of coercive control developing, which builds off of intimate terrorism, but actually goes further and says that violence may or may not even have to exist in this relationship, that the point of violence in coercively controlling relationships is to exact compliance from the survivor. And the coercively controlling partner is employing sort of a constant, continuous, three-dimensional web of tactics. Evan Stark would sort of list them as intimidation, surveillance, degradation, shaming, and isolation. Emma Katz, who Jane had shouted out in the beginning, has added to this list sexual coercion and abuse, economic abuse, isolation, spiritual abuse, manipulating and grooming third parties, exploiting systems and institutions, coercing criminalized activity. And so what you're seeing and what we want you taking away from this is how gigantic the toolbox of a coercively controlling abusive partner may be. And all of these tactics are used sort of in the omnipresent existence of a credible threat of what's going to happen if the survivor doesn't obey the rules, regulations, and systems that their partner has put in place. And the credible threat could be physical violence. It could be getting the survivor arrested or deported. It could be getting custody of the children. It could be withholding necessary support. But the crux of these coercively controlling relationships is that the credible threat is survivor specific, that the coercively controlling individual takes what they know about a given survivor's vulnerabilities and leverages them to get what they want. And that's why, you know, in situational couple violence, you know, a slap may be a slap, maybe a slap, but in coercive control, everything is so context specific, that what we're seeing is sort of very uniquely designed webs of power and control just tightening around survivors. And what we've heard over and over again from survivors is that these non-physical traumatic forms of abuse are often the hardest to recover from, and have hugely harmful effects on survivors and on their children, and you know, require often the most assistance, therapy, counseling for folks to begin to rebuild their relationship with themselves, their trust in themselves and their own epistemology, their ability to sort of navigate the world as they once knew it. And so we're getting a glimpse into just how challenging coercive control is in a relationship, both to define and then to find a way to heal from. And so Jillian then is going to talk to us a little bit about how these things play out in the context of children.
Okay, great. Well, thank you so much. So yeah, we're going to talk now for a few minutes about what coercive control in co-parenting specifically looks like, and the concept of co-victimization, or what's sometimes called secondary victimization. So academics often refer to or distinguish between primary victimization, which is abuse of the adult victim in a intimate partner violent relationship, and secondary victimization, which is which is the negative effects that a child experiences as a result of that abuse of the primary victim. So sometimes domestic violence abuser may abuse both the co-parent as well as the child in a direct fashion. But even when the abuser does not directly abuse the child, that child is experiencing the effects of abuse. And that's what we consider to be co-victimization or secondary victimization. So we know that children experience damaging effects of abuse that they witness. That makes sense, right? We've known that for a long time. And we also know that that includes non-physical abuse. So the types of coercive control tactics that Courtney was talking about that may not amount to physical abuse can still cause damaging effects on children witnessing those incidents. In addition, we are starting to learn that children experience damaging effects from abuse that they don't witness, right? They experience damaging effects from the global dynamic that is coercive control between their parents. And so what does that look like in a co-parenting relationship? I mean, the sort of vastness of options that Courtney mentioned applies here as well, right? It looks, coercive control in a co-parenting relationship looks similar to coercive control in any relationship in that it is unique, right? In that every family is unique, and every abuser uses their own set of tools out of this giant toolbox. But also the fact of parenting and the existence of children in common create a new layer to this dynamic. So specifically, there may be coercive control around co-parenting, so making it difficult for the victim to parent effectively, controlling the victim as a parent, denigrating the victim's parenting, or in general, just creating challenges in order to obfuscate and undermine the victim's parenting. And we can infer from the literature that even if an abuser never involves the child directly in those abuse tactics, the child is experiencing harm. So we sometimes hear, I often hear judges say things like, abusive parent was convicted of domestic violence against victim parent, but the children were never involved, so therefore it's not an issue for custody, right? That is simply not supported by what we know from the research. And so that's something that we need to shift that mindset significantly. But in practice, what we know is it's usually not, this type of abuse is usually not limited to one parent abusing the other parent. The children are often involved in multiple ways. So the children may be used as tools as agents of the abuse, as tools, as leverage points to dominate and control the non-abusive parent. And the abuse may be directed at the children as a means of harming the victim parent. So use of the children capitalizes on the love that a victim co-parent feels for their children and uses that love and loyalty and devotion as a means to manipulate, control, and harm, right? If I harm the child, then the parent is going to experience that harm, right? Or if I threaten to harm the child, or what we often see is threaten to take away the child from the other parent, either through legal means using the court system, and sometimes that's a very credible threat, right? Unfortunately, or through kidnapping or illegal means, or potentially up to, homicide. And so these threats may be particularly credible to a victim who knows that that abuser has that capacity or has acted accordingly in the past. So we see those types of dynamics, and we also see that abusers may enlist the children as agents. So this is a coercive control tactic that undermines the victim's co-parenting or parenting ability by using the children to further the abuse dynamic. So that might look like abuser co-parent undermining the other parent's choices, making parenting more difficult, teaching the children not to respect the victim parent. In one example from our clinical practice, an abusive father told the children that the mother would not join them in heaven because she was a slut, and required the children to write their mother a lengthy letter about how they hated her because she wasn't godly, right? Those types of directed acts of agency where the abuser parent is saying, come here and do this for me, and the children are carrying that out, right? And then we see direct abuse of children, as I mentioned, like abusers who intentionally harm children as a form of what's been termed by some researchers tangential spousal abuse. So abusing the child, it could be another third party, but in this case, we're talking about a child in order to harm the victim. And that may be through emotional, physical, sexual abuse. And we know that spousal abuse is a statistically significant predictor of child abuse, so there is a correlation here. And we also know that intimate partner abusers demonstrate troubling parenting behaviors, such as authoritarian parenting styles, low levels of warmth towards children, harsh and rigid discipline. We know that men who engage in coercive control lack parental empathy and use abusive and manipulating parenting techniques and hold a sense of entitlement and possessiveness towards their children. We also see, the effects of negative role modeling, teaching children to harm the victim parent, to disrespect the victim parent, and also teaching them to accept violence or perpetrate violence in their other relationships going forward. So coercive control happens in co-parenting relationships, and then we bring in the court system, right? So what happens when we bring in the court system? We know that abuse doesn't end at separation. Often abuse escalates at separation. And when victim and abuser have a child in common, there is this legal link in which, that victim parent has incredible difficulty. I mean, it's essentially legally impossible to completely separate from that abuser as long as they have parental rights and can therefore, file custody actions, post-judgment actions, modifications, contempts, and the like. So abusers will often use children as tactics of, or as tools of abuse after separation. That includes litigation abuse, which is, I'll just glancingly mention now because, there's a depth of conversation that could be had on that, but just to kind of name our terms, that's kind of what we're thinking about in this context. So regarding sort of how this affects children long-term, I want to point folks to an article that came out actually a couple days ago in the Family Law Quarterly by Dr. Steph Sloan and myself regarding this topic. So it's called Coercive Control in High Conflict Custody Litigation, and it talks about these effects. So I just kind of in the interest of time, I think, as Courtney mentioned, we'll probably finish this and then talk for hours on the phone about, this topic. We could talk about this forever. So I'll just kind of mention that and say that, the research is interesting because, we have decades of research on this that sort of follows the pattern that Courtney mentioned, which is beginning with focus on physical violence, then beginning to recognize psychological and other types of violence, and now beginning to recognize even more nuanced patterns of coercive control. And so, we have to we're left with making certain inferences about this research. And so it's been a really interesting project to kind of delve into that. But needless to say, it is very damaging for children. There are long-term consequences in the areas of mental health, mood, attachment, academic performance, right, relationships, physical health. And one important thing that I want to say before I pass it back to Courtney would be that we do know that there is a protective effect of certain factors when it comes to, for example, adverse childhood experiences, or which include being exposed to domestic violence. So a child can actually have a buffering effect from certain factors. And those factors include having a strong relationship with a supportive or nurturing, consistent parent. And so when we think about this in a custody litigation context, it's important to recognize that there's a harm that's being caused by exposure to domestic violence, by co-victimization, whether direct or indirect. And there is a potential beneficial effect of maintaining a strong relationship with the primary caretaker parent, which so often is the parent who's being abused. And so we want to just kind of elevate that tension between those two things. And there's obviously, there's a lot more that I could say about that, but I think for now, I'll just pass it back to Courtney to talk next about the criminalization of coercive control as a potential solution to these, horrible effects that we see.
Sure. So it makes sense when you hear about how damaging coercive control is on survivors, on children, to really want to think about, well, how can we help folks? How can we stop this? How can we, deter individuals from engaging in this kind of behavior? And so it's not surprising that, our minds quickly race to, well, we have to make that illegal. We have to punish people who do this. And we are here to suggest to you that is likely not going to be an effective solution, or a solution that is able to achieve those goals. And so where we want to start is really thinking about the fundamental mismatch between what we know about social scientists, what we talked about, and the way that the criminal legal system approaches intimate partner violence. And so rather than exploring motive or intent or being able to look for patterns, the criminal legal system conceptualizes domestic violence simply as a crime committed against a person with whom the defendant has an intimate or a family relationship. We're really looking at violence, threats of violence exclusively. But what we know from our typologies and from coercive control is that what is most important in these analyses is sort of the interstitial dynamics, is sort of the behavior that is swirling around between these big acts of violence, if any, but those all sort of fall out of the bottom of the criminal legal system, which really has this violent incident model focus, rather than looking at who is the primary aggressor, rather than looking at how behaviors have escalated over time. What the criminal legal system is looking for is whether in one moment in time, one person assaulted, perhaps strangled, threatened to do these things to another. And so most of what we know matters in our analysis isn't something that the criminal legal system is built to be able to anticipate or address. And yet nonetheless, we have this big swath of abusive and dangerous behavior that really isn't actionable under the criminal codes the way that they're currently written. So it makes sense that folks would say, well, we really should try to do this. Yes, the criminal system hasn't really up to this point been able to encapsulate this behavior, but maybe we could write something that would allow us to do that. And so that movement is getting a lot of momentum from some pretty big legislative victories overseas. There have been successes in England and Wales, parts of Australia. Scotland is sort of the gold standard for coercive control, criminal legislation. States in the US like New York and Washington and South Carolina have all been for a couple of years now considering legislation that is basically outlawing coercively controlling behavior that causes a person to feel fear or mental distress. Most of these statutes have long lists of examples of things that could constitute coercive control. And we are suggesting that, you know, even our best efforts at attempting to legislate coercive control is likely going to both fall short and possibly create pretty dangerous situations for survivors. And the reason that we're saying this, one, is these kinds of statutes are bound to be plagued by constitutional challenges. Vagueness and overbreadth, for example, are challenges that have plagued most states' stalking and harassment statutes, and coercive control statutes go beyond that point by often not requiring either sort of physical abuse or a threat of physical abuse, by looking at behaviors that sort of outside of a coercively controlling relationship are sort of perfectly legal, perhaps not even frowned upon. And one thing that I think Jillian and I have both seen in multiple environments where we've litigated these harassment and stalking statutes is judges basically saying, this could be anything. Anybody's behavior could sort of be shoehorned into these statutes. And so as a result, I am not ever going to find that there has been stalking, that there has been harassment. And I think that these coercive control statutes at best would fall into tools that judges are really, really, really hesitant to use, because then the floodgates are open in terms of the kind of behaviors that may be categorized as coercive control. We also think it would be pretty hard to, in a criminal setting, triumph in a coercive control case that didn't also include physical violence. Testifying for a survivor is always difficult and traumatic. Here, a survivor would need to sort of meticulously detail years and years of very specific instances that amount to this pattern of coercive control. And there's not a lot of corroborating evidence, right? Often folks are not writing down these rules and regulations. These are discussions that are had in private. There are witnesses. It is really, really hard to prove some of the technological aspects of stalking, the surveilling and monitoring that would be part of coercive control. And so we think it would be fairly difficult without expert testimony, et cetera, for a survivor to be able to prevail as a complaining witness in a coercive control prosecution. And what we're worried about, especially, is that these statutes would instead be used against survivors. We know that law is so often, and particularly in the intimate partner violence context, used by abusive partners against survivors. And a law like this that, you know, doesn't require credible threat that is sort of looking at behaviors that could seem relatively mundane in other contexts. Our concern is that this is going to be something that is sort of used and possibly even more successfully against survivors. Some of the difficulties that survivors have testifying, we don't see that when an abusive partner takes the stand to sort of allege wrongdoings done against them. We also worry that tropes and stereotypes born out of misogyny and misogynoir would make women and mothers more vulnerable to a judge believing that they were being conniving and nagging and manipulative and jealous. And so we worry that some of these behaviors are possibly sort of traditionally coded as being gendered and female, and that it would be easier for a court to believe that a woman may be engaging in these acts than a man. And as always, we're particularly concerned for survivors of color, for survivors with marginalized identities who already have such a challenging time proving that they've been abused when the abuse is pretty clear-cut and obvious, that they would struggle to get law enforcement, judges, juries to believe that they were the victim of coercive control. But because of sort of all of these rampant stereotypes, it might be even easier to convince a court that in fact they are sort of behind the scenes being manipulative and coercive and controlling, and especially given sort of the overwhelming male whiteness that make up the police force, prosecutors, judges, courts of appeals. Our worry is that implicit bias, sometimes explicit bias, may end up making these laws, if used, much more effective to be used against survivors than against their abusive partners. So on that note, we are now going to pivot to talking about sort of the potential for similar legislation in the family context, where some of these problems, you'll notice, remain the same.
Yes. Yeah, so turning then to the family law context, we kind of have asked ourselves, well, criminalization seems to be sort of fraught with dangers for survivors. And what about the sort of civil context? What about particularly in a custody context is what we have looked at. And so, existing custody law focuses on the best interests of the child, and each state has their own approach to what that looks like, including best interest factors. Domestic violence is sometimes one of those factors. There are also presumptions in some states against awarding custody to someone who has been substantiated, where it's been substantiated that they've abused the other parent. And so coercive control may already fit into a lot of these legislative schemes. And so one question is sort of, what problem would this be solving in any given state? And like we said, one thing we're pretty confident about is that, this is context specific. So in any given state, is there a problem that needs to be solved? And then is this particular legislative fix the way to solve that problem? And what are the potential unintended consequences? So we've seen legislatures looking at this question of adding coercive control, like in the protection order context, which, as I mentioned, we sort of are chunking away a little bit from the custody context, as well as in the custody context. So it'll be interesting to see, as some states do dip their toe into this option. I think it'll be really fascinating to see what the results are. And the reality is that courts are dealing with coercive control. Spoiler from my article with Dr. Sloan, not very well, right? And so how can we make this better? How can we create better outcomes for survivors and their children? And so, we come at this from our perspective in our jurisdictions and with our history of also having worked in DC, which had its own unique, nuances. But a concern that we see a lot, I see a lot in Kansas and saw in DC as well, was this idea of DARVO, right? Deny, attack, reverse victim and offender. Abusers coming out really aggressively, as Courtney mentioned, like in litigation, claiming to be the victim, often of parental alienation, potentially even abuse. And if abuse definitions are expanded into the things like Courtney mentioned, nagging and jealousy and sort of manipulation, and often like we see the idea of borderline being thrown around as, you know, very gendered in these contexts. So potential misuse in this context is very similar to in the criminal context. And we have to be careful not to fall into the trap of thinking that, well, a civil case is less serious or less lower stakes than a criminal case. That for many survivors, parents is simply, you know, not an accurate statement, right? The loss of access to children, of the ability to parent on a daily basis is a potentially devastating, life-altering loss that many of my clients, I think, would rather, have a different, consequence, potentially even go to jail rather than have that be the outcome of a case, right? It's just unthinkable for many people. And so this is the highest stakes, as well for the clients involved. So we don't want to dismiss the stakes in any way, right? And so are there things that can be done either in addition to legislative solutions or potentially instead of legislative solutions to solve the problems that we've been talking about, right? So clearly education, changing the conversation around gender-based violence is always important, and we need to keep moving that forward. And as Courtney said, we need to keep improving our understanding of domestic violence, right? I don't think we've solved it. I don't think this is the final, the final form of how domestic violence will be understood, hopefully, right? Hopefully we'll continue to improve. And in the meantime, hopefully we will have, the ability to train judges, family law attorneys, GALs, custody evaluators, case managers, mediators, everyone who is involved in this system needs to be well-versed in the topics of domestic violence, coercive control specifically, DARVO, correct information about parenting rather than misinformation regarding parental alienation and some of these concepts that are really, really poorly understood in our system. Trauma training to help them understand how victims behave, both in and out of court. And really, really important is anti-bias training. Information about documented biases against marginalized litigants, mothers, women, trauma survivors. These are really important topics that cannot be, an afterthought, right? So at the same time, expanding the safety net so that victims have strong support when navigating separation. This is something, I have a contact in Scotland that I've talked to a lot about their legislation, and that's something that's really core to what they've done, is this social safety net, buffering against social erosion, financial devastation, mental health consequences, supporting healing and recovery. These are things that, really need to be central to any solution. And then again, just broadly and socially, promoting a deeper understanding of coercive control and domestic violence, and bigger picture advocacy around healthy relationships, and in addition to information about physical violence and relationships as well. And generally chipping away at the structural components of this problem, because it is a huge problem that has really deep structural components. And our observation is that you can substitute out different statutes or different language or terminology, and courts will find ways of using the same structural inequalities against the marginalized. So with that, I think we'll turn to any questions you might have about the topic. Thank you so much for listening. I'll monitor the questions if anybody has. Someone asked for the link to my article, which I can add for folks who weren't able to find it. But anything else, Jane?
This is phenomenal. Thank you both for all the day-by-day representation that you do, and then your deep thought and work on these issues of coercive control. I am quite certain that probably anyone joining us now or that will listen later really will resonate and have examples similar to And in addition to what you shared in terms of some of the real complexities, and thinking, I was thinking about the extent to which my clients' attentive parenting, is that then going to be called controlling in all of the ways that then there are differential standards and this kind of feeling of impossibility. Um, I I invite anyone to put questions. Either well, we have the Q&A link. We did put within the webinar chat that went out to everyone the link to your article. We also, I believe, on our UCI Initiative to End Family Violence website, which we really intend as a broader resource than to survivors, to practitioners, scholars, beyond the individual programs that we host, to then be that broader resource. So we'll post both of your articles there. Courtney Cross, your article in the UC Davis Law Review, you're both really highlighting the limits, so many of the limits of coercive control in our criminal law and complexities with the utilization. Well, we're waiting to see if any other questions come in. I'll ask just anecdotally something that I'm hearing here in California, where we've had coercive control in our law now for several years. I want to say maybe 4 or 5 years now, as one of the 3 early states to include coercive control in our civil definition of domestic abuse. And I know we've all practiced in multiple jurisdictions, and you're able to then envision more in terms of some of the possibilities. And I really appreciate within our definition how it identifies different examples in terms of use of immigration status that prevents someone from doing something they're otherwise able to do, or the kind of restraints on access to medical care. I know Courtney and I have both done work on HIV-related intimate partner violence and seeing those instances of interference with medical access, and then now having reproductive coercion. So we have from state to state some different definitions of coercive control. There's some concern of maybe a backlash against it even included in our civil law. And I'm wondering if you're aware of research that's now evaluating whether there are cases that are being brought in the civil or the family law context on coercive control, or if judges are really just looking for that physical abuse that I know when we were practicing in DC, you had to prove up something under the criminal code, under the penal code for the civil order. So very different definitions from state to state, but if there is any kind of resistance that has been documented.
Yeah, well, first of all, Jane, so much credit goes to you and your clinic for the massive lift you guys did getting that legislation passed. Jillian and I are dying for data, as I know you must be as well, in terms of how that statute is being used, how effective it is, how often judges are willing to engage with it. We had seen some positive case law a couple of years ago, I believe, out of Massachusetts, with a custody court judge who really did a deep dive into coercive control in terms of making a custody determination. And I don't know that I have seen case law doing the opposite. I know that in my own practice here in Las Vegas, we're having a heck of a time getting judges to buy into stalking and harassment claims. And so I would not feel overly optimistic myself that a judge would be sort of willing to walk the walk with us into coercive control. But Jillian, I don't know what you're seeing out there.
Yeah, not much. I mean, I don't think I have an answer to that question, but I would love to have one. But I also see a couple of other questions in the chat. So I'll just throw these out there, and then
Sure.
if you want to take a shot, and I can come back as well. So 2 questions about the training component. So one is, how can we as survivors educate our attorneys on these matters to better advocate for ourselves, or even the judges or commissioners? And then a question about if we could share our vision for how to implement the kind of cultural shift in legal systems with the judges and system actors. So,
do you want to start?
Well, sure. I mean, I would say regarding how to advocate for yourself as a survivor with your own attorney. I recently also wrote an article about the attorney-client dynamic and some gender elements there as well. So, I mean, I'm a huge supporter of, you know, the client's rights in that situation. I think, you know, you have the right to be represented loyally and diligently and many other things according to our Code of Professional Responsibility. So, I think providing information, finding an attorney who isn't going to be offended or threatened by you providing them information, I think is really important. I would, when you're looking for an attorney, look for someone who has a special expressed interest in training in domestic violence, maybe someone who used to work at a domestic violence organization or a legal aid agency. I think legal aid attorneys often have a particular expertise in this as well. So yeah, and I think survivors' voices are so important in all training and education efforts that we do. So, you know, I would encourage folks to get connected with your state coalition against domestic violence. Let them know that you are a survivor. If you are ready to tell your story, that's such an important voice. And oftentimes I think I, as an attorney, have felt like, oh, I don't want to pressure my clients into feeling like they have to be a spokesperson or something. But if someone is in that place where they're ready to do that, I think that's such a service to the community. So yeah.
Yeah, I agree. And I wish survivors didn't have to do that kind of advocacy with their own attorney. That said, if you think that your attorney is not well versed in sort of coercive control, how it affects kids, how it may impact you in a family court case, I would highly recommend Jillian's article that truly came out a couple days ago that I think would really introduce someone quite nicely to the landscape of coercive control in custody contexts, in sort of what has been branded high conflict custody contexts, which I think sort of strips away the fact that that is usually just code for abusive relationships. I think that is sort of the more palatable title it's been given. But I do think that her article is a great jumping off point for folks who maybe aren't well versed in this. And I totally agree with the idea that for folks who are ready, getting involved in either local task forces, groups like the initiative that we're all here for, state level coalitions, is sort of a great way to start getting your voice heard in sort of the policy advocacy world as well.
Yeah, and I'll just add with the judicial or the legal systems side, I think, you know, if you're an attorney who's interested in these issues, you know, getting involved in state committees and, you know, not being afraid to speak up and offer trainings, offer CLEs, you know, we can never have enough voices on, you know, asking for these changes, and also doing that advocacy in your cases with I'm a huge evangelist of expert witnesses. I think they're incredibly important. You can educate your judge in your case and many other cases through expert witnesses. So yeah, and I see another question, which is any resources for providing coercive control in the state of California or for proving coercive control in the state of California with limited resources. So this, I think, is a question about any ways to document coercive control specifically. So Courtney, what's your thought on that?
I actually think if we're talking about the state of California, that's a great question for Jane, who is sort of our ideal resource on that question.
Great. Thank you. And, you know, Jillian, picking up on the idea of expert witnesses, I'm thinking about the number of times that we file bench briefs as we're also filing petitions. And so thinking about the fact that you may not be able to get Emma Katzen on post-separation coercive control through visitation, for example, but can cite to these published articles and this research. So thinking both about the realities of yes, either bringing in expert witnesses or trying to get in this expertise and educate the judge in that way is something that we do in some different scenarios, and in part to be able to really lay out the law and the relevant case law. We have now a lot of case law published through joint efforts with the Family Violence Appellate Project in California. That is an organization that specifically does domestic violence appeals in the state of California, and now also has a Washington state location. And so that's another great resource to look to. But to be able to then make those arguments from the outset and use the law itself. I mean, it's a hard, it can, I think of Professor Martha Mahoney saying everybody knows what domestic violence is, and we all know it's not us. And so how hard it is to name, but to actually read that section of our law on coercive control and how expansive it is, and then to hold judges to that standard of preponderance of the evidence. It's just more likely than not that here in California, an act or act of abuse, if we're talking about the civil restraining order context. So those are several of the resources I would recommend. And then evidence, we do have the rules of evidence that apply, but thinking about all the different ways in which that can be proven through written statements, through messages, and through witnesses. And so who's able to testify to that? And an individual's own testimony is evidence. And so what our clients are their own best experts and are able to most strongly testify, but the ability to then be able to have that kind of validation and support through advocacy and through representation is, I think, also really essential. So those are my recommendations. Bench briefs, thinking about different experts to bring in. We've also been able to do a lot of judicial training. And so here I am in my office, but looking out at our School of Social Ecology. And so thinking about the extent to which our judges can benefit from being able to learn from child psychologists and being able to learn from these other areas of expertise and have that then really inform the application of the law. And so being able to have some of those moves of judges really learning from so many of these experts that are writing the books and conducting the research and really validating the seriousness with which we need to take abuse and trauma. Going to see if we have any other questions. I know that we're at time, and if there's any final words that you each want to offer, and I just offer my gratitude. Thank you so much.
No, thank you, Jane. And thank you so much for all the work that you're doing. We're really excited to see how your legislative changes are bearing out. We talk so much about how any legislative change like this must be accompanied with the kind of judicial training and sort of development of experts and bench training. And so you are sort of really leading the charge on that model. And so we can't wait to see how that works in a jurisdiction like yours with the support that you're giving the attorneys, the judges, even the litigants. And so we're really excited to see, how all of this shapes.
Thanks, Courtney. And I do want to, I want to recognize Ana Estevez and Assemblymember Blanca Rubio and Susan Rubio, who really led the charge with the initial coercive control litigation here, and Ana's experience of tragedy with courts not understanding what she was experiencing to actually be domestic abuse. And thinking about the importance of all of these fronts of advocacy and to be able to really build on it and make sure that so often there's an implementation gap in the law, but that we also carry this forward. Jillian, anything else?
Thank you so much. It's fascinating, and we're really honored to be here, and thank you so much for having us.
Thank you both for all that you're doing, and I look forward to our continued conversations. And thanks to all who joined us online today. Thanks.